Paul Quinn.
Mr Chair, I move that the question be now put.
I'll hear from the Honourable Trevor Mallard.
Thank you, Mr Chairman. This is a bill. Well, first of all, I do want to place on the record of the House, and I'm sure there will be an opportunity to do so later, my admiration for the work of the Minister of Justice across his portfolios and as a Member of Parliament. I've said sort of publicly that he's a good, honest, straightforward person to work with, someone who keeps his word when he gives it, sometimes slightly reluctant and won't agree to do things that we'd like him to agree to do for as far as both the House and his policy is concerned. But he is a person of absolute integrity and someone who will be missed from the House, and I think it's important that that's made clear. And as I've said in the past, I've seen people come and go across the House from me over a number of years, and the below average ones are numerous, and this member is one who makes up for a lot of them. Mr Chairman, I think it's slightly sad, actually, that so soon after his announcement he's caught in the chair, when the person whose responsibility, the fact that he is caught in the chair at the moment, is sitting not more than 2 metres away from him at the moment. And I think it is important that there's an understanding of how the processes of the House should work, and it's good to have someone in the chair who understands that, and who I'm sure, if he was responsible for some other legislation, wouldn't have got into the pickle that is resulting in the intensive discussion of a bill which I think it's fair to say that we used to agree with, but now that my colleague Charles Chauvel has had a good look in particular at this part, is beginning to get some pretty serious doubts about. But I think it's fair to say, as far as the general principle of the bill, I think all of us know that there are some things to be done in the legal aid area, and this is an attempt. But there are a number of points which I think are interesting, and I'm not sure if the Maori Party have been properly appraised of Clause 5 of Schedule 1 of the bill, because what this clause effectively says that someone's interests in Maori land has to be taken into account in working out whether they can afford to pay for lawyers. Well, Mr Chairman, that might be the equality of everyone before the law, but what we know is that the very way Maori land becomes Maori land under the Te Ture Whenua Maori Act 1993 is that it cannot be disposed of as other land can be disposed of. Now, I think it is fair. There's a fair point in there that the rent from the land, the income from that land, should properly be considered as an individual's income. But I think in considering capital, the disposable capital, suggesting that Maori can dispose of Maori land. And I asked Tariana Turia, does she support, Ms Turia, do you support, Ms Turia, the fact that Maori should have to dispose of their interests in Maori land in order... It's exactly what it says. The disposable capital of the applicant includes Maori land and any interest in Maori land unless the application is made in respect to the proceedings of Waitangi Tribunal or... No, but this is the very point. Because you cannot dispose of it, it should not be included in the disposable capital, and this bill does include it in the disposable capital. And if Paul Quinn can't read that, he should get someone to read it to him. If he, the leading Maori in that party, the leading Maori on justice issues in that party, the only Maori to get a justice bill through the Parliament, can't understand that this bill requires Maori to sell their land, and when they can't sell their land, then, sir, that is something which is particularly sad. It is something which is... I wonder what Tohanari thinks about this. Has he discussed that with his colleague Tohanari? It's clear that Tariana Turia doesn't care about Maori land being sold down the river in a way that one would expect from the Attorney General, but not from the Minister of Justice on this particular clause. Mr. Speaker, I think it's also worth going back to some of the other matters. And one of the questions, and member Tariana now looks and laughs, she thinks it is funny, Mr Chairman, that Maori land should be taken. Mr Chairman, the...
Point of order, the Honourable Tariana Turia.
Appropriate for that member to be lying in the House.
She's gone.
because I was not smiling or laughing, and the comments that he are making are inappropriate.
I hear the member. Look, this has been quite robust this last 5 minutes, and what a member says is not a reflection on the member, I'm sure, and I'd just like the debate to continue in that vein. I'm dealing with this point here. So the point of order that the honourable member has brought up, I think, is not substantiated, and one can actually make comments, and if the member feels that she's aggrieved by what is said, then that's a different matter, but I didn't take it out of the comments that were being said.
The member said I was lying in the House. That requires a withdrawal and an apology. That has always required... I have taken offence.
I'm on my feet. I'm dealing with the point that the member brought up, and I said it's a clean slate. We're starting again. I hear what the member says. I didn't agree with what that member said. We're starting from scratch. You have the call.
Point of order. Mr Speaker, I move that the Speaker is recalled, and to get a ruling on that. The reason for that, Mr Chairman, is that it is always required when a member is accused of lying in the House that it be withdrawn and apologise for.
I hear hang on. There is a standing order 42.3, I think it is, that says that one cannot say that one is lying, and I appreciate that. And if the member feels that I have not acted accordingly, I'll just find the standing. It's 43.
I don't know which one.
42.3.
But I know that every time.
I'll find it. Just one moment. 42.3. 42.5. A particular mode of expression has been ruled out of order consistently has been the use of the word lie. Many other expressions can be used to say that the member is saying something is incorrect, and that is material for debate which goes on in the chamber every day. Right, this is the situation. The member complains that the honourable member said that this member was lying. If that's the case, then I'd ask the member to apologise for that comment.
Point of order, Mr Speaker.
No, I've actually asked if the member said that this member was lying, then I'll just ask the member to withdraw that comment. That's what I'm asking. No, I'm asking to withdraw the comment.
I'll withdraw the comment.
You withdraw the comment?
Point of order, Mr Speaker.
Point of order, the Honourable Tariana.
I'm highly offended by the comments that member also made that were completely untrue, and I want him to apologise to me.
Yes. Right, there is another standing order which I shall refer to. 44.4. It is not the Speaker's duty to intervene. A rejection is not taken to the language used by a member towards another unless the Speaker considers it is such language as requires the Chair's immediate intervention. So this is a situation. The member's withdrawn her comment. She took exception to what...
Did I say she was smiling or laughing? You can't take exception for that. Is that correct?
The member has taken exception. Let's start from scratch, shall we? 44.5, ask the member just to withdraw the comment.
Well, point of order. Well, Mr Speaker, we've had the back and forth on that one. The member was smiling. Mr Speaker, the member was laughing during my speech. I drew attention to that fact. It is a matter of fact. The member mightn't have been laughing or smiling at me, but she was.
Look, it's not
it is a matter of fact.
It's not a matter of personal reflection whether someone's smiling or laughing or whatever. This is getting out of hand. Let's leave it at that. You have the call if you want the call. Honourable Trevor Mallow.
And I will repeat the comments that I make, and that is that I find it appalling that the Maori Party is supporting legislation whereby the asset of Maori land, which is non-disposable, is taken into account when making a decision as to the assets of Maori who are charged before the court as if it is disposable. As I said earlier, I think it's fair enough that the rent, the income that Maori get off that counts as far as their income is concerned, but to pretend that land can be disposed of in these circumstances is wrong, and I think it is shocking that Tariana Turia sits there while this is going through. It's been pointed out to her, and that she's not on her feet defending the principle of the inalienability of Maori land. We thought that was the case. Most New Zealanders think that is the case. We think under the particular legislation, Te Ture Whenua Māori Act 1993, it should be the case. And why is it that during this legislation the member is sitting there and letting those assets be taken into account, and as if they are alienable, even if they're not? Sorry? That's exactly what it is. As I said to the member before, the member should get someone to read it to him. He could get Mr Finlayson to explain it to him. We know he's not the sharpest pencil in the box. We know he's not the sharpest pencil in the box. But sir, if he takes his time and works it through slowly, even Simon Bridges, I think, within an hour or two could get him to understand. Within an hour or two, Simon Bridges could explain it to him. I want to go back to the question of trusts and money held in trust, and seek an assurance from the Minister in the chair that trust, money held in trust funds, is taken into account is taken into account as to when considering Schedule 1 of this bill and the resources of not spouses and partners within the meaning of disposable capital. If someone has a sole interest in a trust or has a sole beneficial interest in a trust, I want an assurance that that trust is taken into account when the Crown is working out whether or not that is disposable capital. Because what we have, and there's a well-publicised court, which I'm casing the court currently, which I'm sure the attorney is well familiar with. I'm not asking him to go into the details of that, but the principles are pretty well established. There is no doubt in this particular case that the individuals have large trust funds. They have a large amount of money tied up within trusts, but they are still making applications for legal aid on the basis that they don't have that money. And that's wrong. It's a rort. There are a lot of New Zealanders who pay good taxes and should not be paying for these multi-millionaires who have their money cut away within the trust systems. They should not be paying for those people to get legal aid when there's a pile of Kiwis who are not getting the legal aid which they should. And where the criteria are far too tough. And, sir, it might even be that some of us would support, if we knew that this area was being cleaned up, if we knew it was being tidied, then we would be happy enough to see a flattening off in the legal aid budget. Although, I say that there are some changes that are being made in this legislation which are useful. Mr Speaker, I also want to ask the question about the 6 months imprisonment. There's some sort of assumption here that going to prison for a crime that's less than 6 months, or in fact not going to prison, there's a judgment made as to likelihood of imprisonment, which, Mr Chairman, is quite a hard one to make. There are cases where at the beginning of the case it seems unlikely that someone, even if they are charged with an offence that is under 6 months, Mr Chairman, this is a very, very substantial, this is the core of the bill, this part, and I think a number of us want to make at least 4 contributions. Mr Chairman, there are people who are charged with this and are likely to lose their liberty through not being properly represented, even though the charges are such.
John Hayes.
Mr Chairman, I move that the question be now put.
I'll hear from